Good morning, I'm Stacey Delikat on this Friday, June 28th. Thanks so much for being with us here on the Law and Crime Network. Coming up this morning, there is a lot to get to, including confessing to the crime. A Florida man accused of stabbing a woman to death tells the jury he did it, and he says he was driven to kill by the government. It was must-see testimony as the defendant took the stand in his own defense, but did he do himself any favors? Today, both sides close their cases before the jury weighs in. All right, so the prosecutor there, Linda Drain Burdick, is beginning her closing statement, laying out a timeline of the events leading up to the murder of Jennifer Fulford. I want to bring in my guest this morning, trial attorney Wendy Patrick, who is joining us live via Skype from California. So, Wendy, I think the big elephant in the room here in that courtroom this morning, even while these closing arguments get underway, is, whoa, what happened there yesterday? I mean, the defendant takes the stand. He admits he killed Fulford. He says he was driven to kill because he was upset with his probation officer. There's so much to discuss here, but I want to quickly get your reaction to that. Did he do himself any favors by taking the stand yesterday?
Stacey, in a word, no. But one of the things that we worry about in criminal trials is that there's something that a defendant says that raises some kind of a mental issue or some kind of sympathy that might actually sway the jury. I don't know that that happened yesterday. I watched that testimony. If anything, he's a grievance collector. It was a misdirection of anger that should have been towards his probation officer that was directed towards this innocent, beautiful woman. So it's one of those things where a jury listened to how articulate he was, how polite he was, and how calmly he explained exactly what he did and why. So no, he did himself no favors by basically admitting to the crime. Obviously, the prosecution has to prove it independently also. But he did himself no favors in telling the jury why he did it, and of course that he was the one responsible.
It's interesting because you said the word polite. Now, I mean, he was not, combative, I don't think, really. I mean, he wasn't, insulting to the prosecutor or anything like that, but he was a little short at some points. And when she started asking him questions about the incident, he said, I'm not going to sit here and answer your questions. There were times I would argue he was impolite.
Yeah, but overall, he listened, he responded to questions. He was appropriately defensive because he's guilty. And that is part of what I think the jury got to see. But some of the questions that were uncontroversial and didn't hurt him, he was enormously polite. He used her name. He asked her to repeat herself. He didn't understand a question. He became defensive when the questions became a little too close and personal. But remember, he took the stand in his own murder case, so he should have expected that. So the demeanor shift, Stacey, as you point out, is something else that does not inure to his benefit, because the jury has the chance to see how he can be both civil and then slide to uncivil so quickly, depending, as you point out, what he's asked. And that's apparently what happened when he made the decision to commit this crime.
All right, so it appears the prosecutor here is perhaps getting close to wrapping up this closing argument as she tries to convince jurors to find Scott Nelson guilty of first-degree murder of Jennifer Fulford. I want to bring back my guest who's joining us live via Skype this morning, Wendy Patrick, trial attorney. Wendy, what is your overall assessment of how this closing argument has gone so far?
Well, the prosecutor is doing an excellent job of laying out what she described accurately as a timeline. There is nothing worse than jurors being confused as to what happened when. They need a storytelling element to every case, even a case like this where the defendant takes the stand and admits guilt. They still have to understand exactly what happened and when. And my goodness, Stacey, I grew up in a day and age where we couldn't prove where somebody was by looking at pinging on cell phone towers. We have come so far that it is a lot easier to be able to trace exactly what Mr. Nelson did and when, and exactly how this victim was moved to and from the scene of the murder and when. And to put it in context very slowly and methodically is a great way to have these jurors first to be able to keep their attention and to have them understand in a human way exactly the way this unfolded, the amount of time there would have been for reflection upon what the defendant was about to do, and then ultimately in being able to take all that into consideration in deciding how to find and what kind of a verdict to return.
Yeah, I agree with you that she's being very thorough there. Interesting to me, that Nelson essentially confessed to all of this yesterday. So, I mean, yes, of course she wants to cross all of her T's and dot all of her I's, but it's almost like he did the job for her to an extent. So as the defense gets ready to begin its closing, quickly, let's talk about the prosecutor's closing. She ended there with the premeditation. Obviously, that is key for her to convince jurors that the murder was premeditated. Do you think she did an effective job, Wendy?
Yeah, she really took her time. And that is very important in a case like this, where sometimes there's a temptation, especially when you have a confession, to think that it's open and shut and simply end with, well, ladies and gentlemen, you heard him tell you what he did, without remembering there's more to the story than that. This jury's going to have to go through that timeline and decide how much time did he have to think about what he was going to do? How many opportunities did he have to reflect upon the severity of what he was about to do and the acts that he was about to commit? What kinds of things factored into the sophistication, the level of pre-planning, which makes premeditation? So the way this prosecutor laid it out gave them all the ammunition they needed. It's one thing to have sat through a trial, but to have this type of a summation really was valuable for them to be able to reflect and put it all together.
Yeah.
Frankly, I'm interested in what the defense is going to say to rebut that.
I was going to say the same thing, Wendy. Now let's see what the defense says. We're going to take a very quick break. We'll be back with much more live. The defense's closing argument right after this break.